A major court ruling could have implications for voters and elections across the nation. A federal appeals court ruled only the U.S. Attorney General can sue over alleged electoral discrimination under the Voting Rights Act.
Now, Virginia lawmakers and civil rights groups are raising concerns. Eugene Daniel explains why.
It's a devastating ruling.
It's a tough blow to the Voting Rights Act. A federal appeals court says people in groups like the NAACP and the ACLU can't sue under a key section of the landmark civil rights law that bars racial discrimination in voting. Some experts say they fear it could gut protections under the legislation that dates back to 1965.
This is a judge taking the line from one justice and deciding to upend the crown jewel statute of the civil rights era.
The ruling says only the nation's top prosecutor, the U.S. Attorney General, can enforce a portion of the law that requires political maps to consider districts where candidates favored by minorities can win elections.
And if the Department of Justice decides, for whatever reason, not to bring the cases, then the victims just have to suffer until they can find a Department of Justice that will rectify the situation.
Virginia is not one of the 7 states impacted by this ruling, but the decision could set up a voting rights battle in the U.S. Supreme Court. And that's something Congressman Bobby Scott is keeping an eye on.
If you eliminate the protection of the Voting Rights Act and leave it up to the whims of the Justice Department, there's no telling how far back the clock can be turned.
And it's not clear whether the groups will appeal, but the ACLU is reportedly exploring its options.